We've gone over the most important document. Now let's go over the rest of it. Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. Okay, so just like I mentioned, we went over the most important document and the newest documents that dropped between Bryan Kohberger and the state of Idaho when it comes to the Moscow murder case. The biggest fight right now, besides proving whether Bryan is innocent or guilty, is proving exactly where and when Bryan's DNA was actually obtained, because his defense team is claiming, and say that they can prove it in the Frank's motion filings, that his DNA was actually illegally obtained. There's been a lot of questions when it comes to his DNA, how it got there, just the simple fact that it's touch or transfer or anything on that low level when it comes to DNA evidence says that it could be faulty information that literally might mean nothing. And I know that a lot of people act like that's not a thing, but I will forever go back to the Lucas Anderson story, where not only was this man's DNA found underneath the fingernails of a murdered victim, but he also confessed to the crime. It took a very, very smart lawyer to put together the fact that Lucas Anderson actually shared an ambulance ride with the murder victim on the exact same night. He was actually in the hospital recovering from falling unconscious onto the floor of a gas station from being way too inebriated and all messed up on several different things. And because of his abuse of substances and alcohol, he literally confessed, thinking that he might have actually done something in one of his blackout moments from being so intoxicated. But it turns out he was completely innocent. So you have a double whammy. You have his DNA under the fingernails of the murder victim, and homeboy is confessing, and he had nothing to do with it. That's why this fight for the IGG information to be public is so important. Not just in the Idaho 4 case, but it should be important to you, an American, because your rights are being violated every single day if you've done anything when it comes to this DNA stuff. And I'm not just saying that because this case and how things are going. Go and do the research yourself. I did a video about 23andMe. I've mentioned it a few times. Again, this is what it looks like, but don't just trust the things that I'm saying. Go out and do your own research. This DNA stuff is dangerous when it comes to protecting your own privacy. So again, we've already gone over the most important document when it comes to Bryan Kohberger's team demanding that it be public for us all to hear and see what's actually going on with the IGG DNA information. Let's go ahead and get started going over the rest of the documents. Now, before these became public on the 16th, we had stopped at all of these right here, and we really didn't go over anything because all it was normal formatting for all of these things to be sealed, and there was no reason to make a video about any of it. But what I did see whenever we also talked about the information on the case summary page that we did the Wednesday before these came out was that there was a first supplemental response to discovery from the defense side, and that was the first time that we had seen that. All it says is Bryan C. Kohberger, by and through his attorneys of record, hereby submits the defendant's first supplemental response to discovery to include documents, photographs, and data as required by Idaho Criminal Rule 16. Exhibit A, which is an index of discovery provided to the state, will be filed under seal pursuant to ICAR 32. Should additional information become available, Mr. Kohberger will timely supplement his discovery response. So whatever they gave over there includes photographs. Obviously documents and data, but just the simple fact there's also photographs involved. Like, I'm really super freaking curious about what it could be. Then we have this stipulated motion to seal defendant's witness and exhibit list for motion hearing on 1/23 of 25. Comes now Bryan C. Kohberger by and through his attorneys of record, and with a no objection from the Latell County Prosecuting Attorney's Office, hereby moves the court for an order to seal defendant's witness and exhibit list for motion hearing on 1/23/25. Now, I am interested in why they want to seal the witness list after coaxing so much information out of the state. Now, we've got subpoena ducis tecum, expert witness subpoenas, but we also have more than one regular schmegler. So could it be for the two surviving roommates? Could it be for Dylan and Bethany? I'm hearing so many things in the back end about what they are apparently trying to do. I don't have any proof of any of it. I just know that it tracks to the behaviors that we've already seen about how they just are kind of just like living their lives like none of this happened, and they want to just like not really show up and testify. And my whole thing is, if you really thought that this was the guy that did this, that apparently traumatized you so bad that you couldn't actually talk at the memorial, you had to have somebody read a letter out loud, and you're just so traumatized, why wouldn't you be willing to come back and testify against him knowing that he's behind bars and can't get you? The boogeyman's put away, baby. So what are you so scared of? That's another reason why I just don't believe that they're just going to pull some magic something out of a hat and make me believe this, because why in the hell are Dylan and Bethany behaving that way? Make it make frickin' sense. Now, we've had new protective orders filed, and I don't know for sure whether it is a person or it's documents. It can apparently be documents, according to some paralegals who have made comments, which I guess we've seen that before, but I've just always taken it as they're sealed. But this is also sealing a protective order. And we've had the no contact orders re-upped because they expired. So I don't know if this is something to go along with that or if this is something else. I'm not going to pretend like I know. I'm just as confuzzled as you, okay? I don't know. But whatever it is, the state is not objecting to them wanting to put seals on anything. And again, I find it funny. I find this so hilarious, okay? This is a murder trial, right? And we're hearing that the stuff that's going to happen closed is going to be remote session, right? I couldn't remote in for my DV case, which is like wild that this can be appropriate. So Zoom can be appropriate for a quadruple homicide, but for a DV case, it's not, which makes no sense to me. But also just the simple fact that they are able to just say no objection via a text message, and it's perfectly fine and legal. Like no notary, no nothing, just send the text message through the phone. It's just, it sounds so unprofessional, and I just cannot help but bring up the crap that I went through for something not as severe as what's happening here. The stipulations and the crap that they tried to pull. And this is like how this whole thing is being taken care of here. It's just wild to me. Now, this is the one that we went over already. And now we have the order granting the defense to be able to exceed the page limit. They asked to go over the page limit, and I'm glad that they went ahead and did that this time, because they went like 2,000 pages deep on something, and Hippler was like, what in the hell is this? Why did you send this to me? Why did you give this to me? Did you really think that I was going to go through all of this? Of course not. So they had to shorten stuff down. Hopefully it doesn't take away anything important that should have been in there, but 2,000 pages is really like a super lot. But they were allowed to apparently exceed that for the stuff that has to do with the IGG, which is good, because the page limit for whatever this is for the motion to suppress and memo in support of the IGG info, page limit 10 pages. 10 pages? I could write 10 pages just on how my crappy day went at work because of these insurance companies getting on my nerves on a daily basis. 10 pages for a quadruple murder case when it comes to the IGG information, i.e., the only reason why Bryan's even in jail right now. 10 pages. Wild. Let's see how many they actually do, though. Because if the limit was 10, how many are they allowed if they're allowed to exceed it? Because it's not giving them like another limit. They're just like, yeah, you can go over 10. I wonder if it's going to be another 2,000. Now we just have them doing the order to seal the defendant's witness list, also to seal the defendant's discovery attachments. This one is to seal attachments for the motion to compel. Now, there looks to be some amended expert disclosures from Mowry that has been attached. I feel like we read something like this already, so I wonder if this is just like placed out of order. Now, whatever the S10 is has to do with Lawrence Mowry, but then there's other attachments that are also filed. Now, I wonder if there's any other information on there besides what's already in the search warrants, and where could it have possibly been if it wasn't already attached to those? Unless this is something else that he's written up and he's just now like submitted it. I guess we'll maybe hopefully find out soon. And here again for the sealed protective order. See, it's interesting to me that this sealed protective order thing, because whenever we have the protective orders for the family members, we have like their initials at least, right? But this makes it sound like even what's being protected, we're not allowed to know what it is. it's just getting interesting because we're getting into territory to where like I can't even cognitively try to figure out what it is with just common sense. It gets way too into the law part of it. Now, this is where we figured out on the case summary page all the way back on Wednesday on the 15th that we were going to be having a hearing coming up on the 21st at 10 o'clock in the morning. Now, I'm not really quite sure how we're going to know what actually happens in there unless something gets said on the 23rd and the 24th. Because with as slow as Ada County has been in actually getting documents up on the public website, whatever might actually get filed at the end of the day on the 21st probably will not be available by the time court starts on Thursday. I just don't feel like it's going to get out on time. So who knows? I mean, unless they have a way to get something out to the public before then, we probably will not know for a hot minute what's going on here. But this is how this one is worded. It says on January 21st at 10 a.m. Mountain Time, the court will hold a closed/sealed hearing by remote video, which means 1, hear the defense motion to unseal materials related to its request to suppress evidence stemming from the use of IgG DNA, and 2, consider what portions, if any, and under what circumstances should the various motions set to be heard on January 23rd and January 24th be open to the public, either live or by video. So there's also a huge possibility that all of it will be closed to the public, even the stuff that's not about the IgG. Let's just cross our fingers, okay? Because this is getting absolutely insane. The clerk will provide a video link to the attorneys of record who request a link into the Ada County Jail so that defendant may appear via video. The Ada County Sheriff is hereby ordered to provide a secure and private space for a defendant to appear by video for his hearing. Now it's around 2:30 p.m. Texas time. That seems to be it for now. If the case summary updates or there's new documents that become public by the time this comes out around 7:30 this evening, I will definitely do my best to insert that in here. But for now, let me know what you guys feel so far about these documents and the upcoming fight to allow the IgG information to be heard public. Let's cross our fingers that they actually allow this because, again, they have done a really piss poor job of trying to convince a lot of people, the majority of people, in my opinion, that Bryan Kohberger is either the only guy or just involved at all. They're really not doing a good job of that whatsoever. So I don't know if they're going to approve this to be public or not, but if Judge Hippler really is so strict about rules and making sure that everything gets done by the actual book, then he'll follow the Constitution and he will allow all of this to remain public. We'll see just where Hippler really stands. All of this is a judge of character, I promise you that. Let me know what you guys feel about all of this down in the comments. If you like the way that I present this information and give my opinion, please don't forget to leave a like on the way out, subscribe to the channel if you were not subscribed already, and please don't forget to make sure that that notification bell is set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives. See y'all.